Hello future judges, this is Annapurna and today I am going to teach you Order 7 Rule 10, that is return of plaint. So first of all I would like to explain this concept with the help of a very simple example so that you can understand it better. Okay. So in our example, suppose there are two parties, okay, Mr. A and Mr. B. So in our example, suppose there are two parties, Mr. A and Mr. B. So suppose here Mr. A has filed a suit against B. Okay. Suppose this is the court and in this court Mr. A has filed this suit against Mr. B. Okay. Now on this point Mr. B has submitted his written statement. Okay. So Mr. B has submitted his written statement. And in his written statement, Mr. B has raised a preliminary objection regarding jurisdiction of the court. Means, see, Mr. A filed this suit in this court. Why? Because Mr. A believes that this court has the jurisdiction to try this suit, that is Mr. A versus Mr. B. Now, Mr. B in his written statement has raised a preliminary objection regarding jurisdiction. Why? Because he believes, that is according to Mr. B, that no, this court does not have the jurisdiction. Okay. Now, you may ask me, what is preliminary objection? Okay. Now, you may ask me, what is preliminary objection? See, preliminary objection can be raised on various grounds regarding maintainability of the suit. Okay. So, preliminary objection can be raised on various grounds regarding maintainability of the suit. Maintainability of the suit. These grounds may include lack of jurisdiction. These grounds may include lack of jurisdiction. It may include bar of limitation, or there are so many other grounds also. But for Order 7, Rule 10, we will focus on the issue of lack of jurisdiction. Okay. So for the purpose of Order 7, Rule 10, we will focus on the issue of lack of jurisdiction. It means when we are talking about return of plaint, when we are talking about return of plaint or Order 7 Rule 10, then the preliminary objection is usually raised on the ground of lack of jurisdiction. Okay. Now the question is whether the return order will be passed only on the ground of lack of jurisdiction. So now the question is whether the return order will be passed only on the ground of lack of jurisdiction. So generally the answer is yes. In 99.99% cases, return order will be passed only on the ground of lack of jurisdiction. But there is a section, that is section 151. So by virtue of this section, court has wide power. By virtue of this section 151, court has the wide power. And this is known as inherent, this is known as inherent power. So under section 151, court can pass return order in any other cases also. Okay. So this is all about the preliminary objection. Okay. Understood? Now suppose somewhere here on first hearing, court will see this preliminary objection. Okay. So on first hearing, court will find this preliminary objection. So either on first hearing or any other subsequent date, court will frame a preliminary issue. Now you may ask me, what is preliminary issue, right? See, who will frame the issue? Always remember that court will frame the issue. Okay. So always court will frame the issues. Okay. See, issues can be two types. Issues are two types. It can be preliminary issue or it can be issues on merit. So issues can be two types. It can be preliminary issue or it can be issues on merit. Okay. Now preliminary issues. See, preliminary issues are framed on the basis of preliminary objection of the suit. So preliminary issues are framed on the basis of preliminary objection of the suit, and issues on merit are framed on the basis of cause of action of the suit. Okay. So preliminary issues are framed on the basis of preliminary objection of the suit, and issues on merit are framed on the basis of cause of action of the suit. Okay. Now you may ask me, what is cause of action, right? See, if somebody asks you what is your cause of action, never say that Mr. X, Y or G has violated your legal right. This approach is not right. So whenever somebody asks you what is your cause of action, always say that I have a legal right existed in me and some X, Y or Z has violated that legal right, and that's how I got a cause of action, that is right to file a suit. Okay. Now coming back to this point, that is issues. Okay. So issues can be framed only on those facts, which are denied by the opposite party. Okay, so issues can be framed only on those facts which are denied by the opposite party. Okay, so in our example, Mr. A has filed this suit in this court. Why? Because Mr. A believes that this court has the jurisdiction. Okay. And Mr. B, that is the defendant, filed a written statement, and in his written statement, he has raised a preliminary objection, stating that why? Because he believes that this court does not have jurisdiction. Okay. So plaintiff is saying something and defendant is denying. So on this controversial point, preliminary issue will be framed. And who will frame the preliminary issue? Obviously, court will frame the preliminary issue. Okay. So, what will be the preliminary issue? The preliminary issue will be whether this court does not have the jurisdiction to try this suit. So, what will be the preliminary issue? Preliminary issue will be whether this court does not have the jurisdiction to try this suit. Now, there is an important concept in CPC which is very much relevant in this context, that is presumption of jurisdiction. So, there is an important concept in CPC, that is presumption of jurisdiction. See, presumption of jurisdiction means, suppose A has filed a suit against B. So, A has filed a suit against B. A has filed a suit in this court against B. Okay. Now, this court will presume that it has the jurisdiction to try this suit, that is A versus B. Means, whenever a suit is filed in a court, then that court will presume that it has the jurisdiction to try this suit. Okay. Now, suppose B, the opposite party, has raised an objection regarding the jurisdiction. That is, B says that no, this court does not have the jurisdiction to try this suit. Okay. Now, in this case, burden of proof will lie upon B. Why? Because in this case, burden of proof will lie upon that party who raised the objection, who raised the objection regarding the jurisdiction. Because according to B, this court does not have jurisdiction. Okay. So, burden of proof will lie upon B to prove how this court does not have the jurisdiction. So, in our example here, Mr. A has filed this suit in this court. So, this court will presume that it has the jurisdiction to try this suit. Now, Mr. B, that is the opposite party, has raised a preliminary objection stating that no, this court does not have the jurisdiction. So here burden of proof will lie upon B. B will prove that how this court does not have the jurisdiction to try this suit. Okay. Now coming back to this point, that is court frames this preliminary issue. Okay. So after framing preliminary issue, court will postpone the hearing on merit. So after framing preliminary issue, court will postpone the hearing of the suit on merit and court will conduct a hearing on preliminary issue. So court will postpone the hearing of the suit on merit and court will conduct a hearing on preliminary issue. It means both plaintiff and defendant will present their evidence as well as argument. So, it means both plaintiff and defendant will present their evidence and argument. Now, as we all know, defendant has raised the preliminary objection. In our case, B has raised the preliminary objection regarding jurisdiction. So, burden of proof will lie upon B. So, B will prove B, that is the defendant, he will prove how this court does not have the jurisdiction to try this suit, and thereafter plaintiff, that is A, Mr. A, he will counter. Okay. So now somewhere here court has decided that no, this court does not have the jurisdiction. So here court has decided that no, this court does not have the jurisdiction. Okay. Now what will be the consequence? So now court will return the plaint to the plaintiff. So court will return the plaint to the plaintiff under order 7, rule 10. Okay, due to lack of jurisdiction. This jurisdiction can be lack of territorial jurisdiction, it can be lack of subject matter jurisdiction, or it can be lack of pecuniary jurisdiction. Okay. Now, court return the plaint to the plaintiff. This is an order. Okay. This is an order. This is not an judgment. Why so? Because this is an order, because the hearing of the suit on merit has not been conducted. So, hearing of the suit on merit has not been conducted. That is why this is an order and not a judgment. And this order is an appealable order. This order is an appealable order under order 43, rule 1, under Order 43, Rule 1 and Sub-Rule A. So, court decides to return the plaint to the plaintiff. Okay. Now, plaintiff has three options. Okay. So, first option plaintiff has, plaintiff can file an appeal. Okay. Plaintiff can file an appeal against this written order to the appellate court. Okay. Under Order 43, Rule 1, Sub-Rule A. Now, if this plaintiff goes for appeal, thereafter Order 7, Rule 10, B will apply. Okay. So, second option plaintiff has, plaintiff can take the written plaint and file it in the proper court by himself. Okay. So, plaintiff can take the written plaint and file it in the proper court by himself. This is broadly covered under Order 7, Rule 10. Okay. Now, the third option plaintiff has, instead of going to the proper court and filing the written plaint in that court, plaintiff can go to the trial court. Trial court means the same court which has passed the written order. He can apply there that please fix and date of appearance for both me and defendant in the proper court. Okay. So, this is covered under Order 7, Rule 10A. Okay. Now, who will suggest the trial court that this is plaintiff's proper court? So, who will suggest the trial court? Trial court means the same court which has passed the written order. Okay. Who will suggest this trial court that which one is plaintiff's proper court? Plaintiff will suggest the trial court that this will be my proper court. Okay, and under Order 7, Rule 10A, he may apply to this trial court that please fix and tell the court that please fix an date of appearance for both the parties, that is both plaintiff and defendant, so that on that particular date both plaintiff and defendant can appear in that proper court. Okay. So, I am signing off for now. See you in the next class where we will dive deeper into these topics, and the Bengali version of this class will be uploaded soon. So, bye for now. Best wishes for your future, and I hope you will become a judge soon. Take care.